My name is Jennifer Tharrington, and I'm a partner at the law firm of Haas & Associates. Our website can be found at www.carolinafamilylaw.com. This is a presentation on assisted reproduction for LGBT patients and same-sex couples. Prior to understanding the parentage rights available to same-sex couples in North Carolina, we have to make sure that we understand the effect of nationwide recognition of same-sex marriage. First and foremost, same-sex couples who are validly married in other states are now validly married in North Carolina. They do not need to get remarried or take any other action in order to have their marriage recognized. Same-sex couples that were not married in any state can now legally get married in North Carolina. Same-sex couples that have a legal relationship status, such as a domestic partnership, a civil union, or a marriage in another state, do need to address and dissolve that relationship before they can validly marry a new partner in the United States. So how does same-sex marriage affect parentage rights? All of the parentage rights that are predicated on marriage that were available to different sex couples are now available to same-sex couples. However, just as different sex couples were required to actually be married in order to avail themselves of certain parentage options in North Carolina, same-sex couples are now also required to actually be married in order to have the full gamut of parentage options available to them. If you are in a same-sex relationship and you intend not to get married, it's important that you speak with an attorney to make sure that you understand what legal options are available to you regarding parentage of your children. The legal landscape currently in North Carolina is slightly different for female same-sex couples than it is for male same-sex couples. So I'm going to start with explaining some options that are available to female married same-sex couples. The most common situation for a married female same-sex couple is a situation in which one of the intended parents is carrying her own egg, which was fertilized by the sperm of an anonymous sperm donor. What to know if you're in that situation is that the law in North Carolina currently uses gender-specific language regarding what we call the marital presumption. And what that says is that a woman who gives birth to a child in North Carolina is presumed to be the child's legal mother, and her husband, if she has one, is presumed to be the child's legal father. In May of 2015, North Carolina Vital Records decided to extend this marital presumption to married female same-sex couples. And what that means is that currently, if a woman gives birth to a child, her same-sex female spouse can add her name to the initial birth certificate right there at the hospital without taking any further legal action. However, and this is a huge and crucial however, the law does not explicitly support this extension. The law still says and still uses the word husband. As such, having your name on a birth certificate in and of itself does not make you a parent. North Carolina Vital Records, though admirable in their desire to support equality, is in charge of generating documents. They're not able to actually change or expand the law. So there's actually, in this case, no official legal status that supports the parental rights of the non-biological mother, despite the fact that her name is on the birth certificate. So what does that mean? That means that the wife of the birth mother should do a confirmatory step-parent adoption to ensure that there is a permanent and lawful legal status of parental rights that supports her name being on the birth certificate. It is the adoption decree itself and not the birth certificate that will make a person a parent under North Carolina law. A second scenario that's also common for female same-sex couples is a situation where one of the intended parent gives birth to an embryo created from her own egg and the sperm of a known sperm donor. What to know and what's crucially important if your family falls into this situation is that the only way to legally sever the rights of the known sperm donor is to do a step-parent adoption. If you don't do a step-parent adoption, conceivably your known donor will keep his parental rights and could assert them at any point in the future, despite the fact that both moms' names are on the birth certificate. It is unknown how a judge in North Carolina would rule in the event that a known donor petitioned for parental rights or custodial rights, but we can say that it is the law that a genetic parent's parental rights generally do trump the rights of all other people. In other circumstances, such as the case where a woman gives birth to a child and her husband is placed on the child's birth certificate, but another man shows up with a DNA test and can prove that he is in fact the genetic father of the child, that man's name will replace the name of the birth mother's husband on the birth certificate. If you apply that same status to a same-sex female couple with a known sperm donor, the fear is that the donor can demonstrate his genetic parentage to the child, and that a judge could potentially order that his name replace the name of the birth mother's spouse, and that he potentially even be given parental or custodial rights. That's why it is crucially important that if you're using a known sperm donor, you complete a step-parent adoption and don't just rely on the birth certificate. Moving on to assisted reproduction for same-sex married male couples. Currently, however, same-sex male couples will need an attorney to assist them with choosing and completing the right legal process depending on the specific circumstances of their family. So what are the most common options? Most of the time, same-sex male couples end up doing a pre-birth order or a parentage order that orders the name of the biological father to be placed on the initial birth certificate, and it removes the name of the gestational carrier and her spouse if she has one. They then complete a step-parent adoption, which adds the name of the biological father's husband onto the birth certificate and gives him parental rights and status as the second legal parent. A note here about step-parent adoptions. A lot of my LGBT clients have said that they're somewhat offended by the term step-parent adoption and that they feel like it gives them sort of a second-class citizenship in terms of their parentage rights to their child. And my response to that is that step-parent adoption, the term step-parent is really used to describe the status by which you can access that type of adoption. So by being the spouse of the biological or genetic parent, you are able to petition for a step-parent adoption. However, once the adoption is completed, you are no longer a step-parent. You are considered a full and equal legal parent to the biological parent. So you shouldn't feel like you've received anything less or anything less significant or less important than what the biological parent has. It's merely just a term that's used to describe the type of adoption that you initiated in order to become a full and equal legal parent. Finally, I want to go through just a few more advanced or complicated scenarios that if you find yourself in one of these situations, you should definitely speak with an attorney to make sure that you understand what your legal options are in the event you choose to grow your family in one of these ways. First, if you are not married and don't intend to marry. Next is if for a same-sex male couple, if you have mixed your sperm and or you have transferred an embryo, one of each was related to each biological father. So you don't actually know who the genetic parent of your child or children is. If you've adopted an embryo or had one donated to you such that the child is not actually genetically related to either of the intended parents. If you're in a same-sex female relationship and one of the female partners is carrying an embryo that's genetically related to the other female partner. If you're considering using a traditional surrogate. If you're considering using a known sperm and or egg donor. And finally, if you're considering having a family member act as your gestational carrier. Those would all be situations in which you would want to contact an experienced assisted reproduction law attorney to make sure that you understand what your options are on the legal end to achieve the type of parentage and the type of family that you're looking to build.